Frank Tete, if you can hear me, if you could please unmute your microphone. We're starting right away. Wow, delighted to have you, Frank Tete. Please, if you can unmute, good. So we're on the same page. Ladies and gentlemen, it is one of the most important discourse in recent time. The discussion about the new CAMA has been in the public domain for a couple of weeks, because it's not up to a month. And it's been an uphill conversation. What exactly is the problem? On this conversation, I'll be interrogating this discussion with one of Nigeria's finest lawyer, civil rights, human rights, all the rights lawyer. Frank Tete is also the executive director of CASA. Frank Tete, you are welcome.
Thank you, and I welcome everybody to this important conversation. It's very important because of the interest that it has generated. I want to thank the Center for Democracy and Development for putting it together, and I welcome every.
Frank Tete, you are mute.
I thank you for that, and I welcome everybody to be part of this conversation. We have the law before us, a new law, which in my own humble opinion, I do not think has changed much from what has been before, apart from the additions, which are not our concern today. But today we are dealing with the section that regulates not for the not-for-profit sector, the area that where you have mosques and churches and NGOs being registered under law. If you remember, and to my surprise, I wrote a brief article on this last week, and it was so widely published by the papers, traditional papers for that matter, to my surprise. And that shows you the level of interest this has generated. And in that article, I tried to make everybody to be calm, that nothing has actually happened. No big deal with regards to the almighty section 839 that has generated the kind of furore in the leadership of many religious organizations. So if you would permit me, I would like us to look at the relevant sections of the law very briefly, because I can see, I can see the retinue of very highly respectable persons that have joined us. And it's important that I do this very quickly so that we can also have their feedback into all of these. So without wasting much time.
Hello, Frank Tete. Hello?
Yes.
So just to put it, this session correctly, just 1 minute. This conversation is going to be more interactive. I know the session you're talking about, but I want us to have a background to this conversation. A background to this conversation. What is the new act about?
All right, that's the new act is with regards to NGOs and religious organizations. The new act is meant to create a sense of democracy in the management of these institutions. The new act also aims at creating a sense of transparency and accountability on the part of the leadership. And then the new act also can I continue?
Just 1 minute.
Yes, what should I do?
No mute, please.
Mute your microphone. Okay. So,
can I continue?
Please continue. Kindly, everyone, please do mute your microphone because you are not supposed to tamper with your microphone at all. Just kindly let it be the way it is. Thank you so much. Please, Frank Tete, you have the floor. What
All right, so
new
it's also to increase transparency and accountability of the leadership of this organization to their members. And now, this is very interesting. Membership of NGOs and religious organizations have now been put in the forefront of this act to be persons who now have powers, a lot of powers. Before now, when you talk about particularly Section 839, when you talk about the powers to suspend the registered incorporated trustees, it is actually the members, 1/5 of the membership, that can make that petition to the court for the purpose of the suspension of the leadership, or I mean the trustee of such organization. So, this law has empowered, has created, has now brought attention to the membership of these organizations, particularly with Section 839. So if you ask me, the things that have changed, the new things that this law is bringing with regards to not-for-profit organization, it is the power to suspend.
Your internet is not. Yeah.
Which wasn't. It's not something new. The trustees could also could have been suspended before now, but it has made in such a manner that the trustees can now be suspended for various reasons on the petition of the members or on the petition of CAC itself. So these are the new things that the law has, this new law has brought, and it has also made provisions for. Before now, CAC does have the powers to transfer the property of an NGO or a religious organization. It does have the power to transfer to another organization upon dissolution. But in this case, this new law now places a mandate on banks to report to CAC any NGO or church or mosque that has a dormant account, for the purpose of having the monies in that account transferred to, and first of all, a direction given by CAC for the purpose of transferring those monies to another NGO or to another religious organization in the case of, in that case, in order to carry out the objects that are similar to the formally registered organization. So I don't see much difference other than the heightened need for transparency. There is now the annual returns will also continue, but statement of affairs will now have to be filed on a 2-year, on a biannual basis. That is, statement of affairs in addition to annual returns, which is now going to be done in the prescribed form by CAC. So apart from transparency and improved corporate governance, nothing much is really new, because we have had the Financial Reporting Council imposing these standards on not-for-profit. The Financial Reporting Council cannot impose regulations on companies, but it can for the purpose of not-for-profit organizations.
Okay, so Frank Tete, you sound as if there's no big deal in all of these new acts. Is that what you're saying?
Yes, there is not. But before I go on, let me quickly acknowledge the presence of course, we have respect in the bar. I can see the chairman of the
Permit me to do my introduction.
Please, if you cannot introduce, if not, I can continue.
Don't stampede me. Don't stampede me. Calm down. Let me formally welcome the honorary chair of the MBA Abuja, my very distinguished personal person. Permit me to use the word, my madam, Awa Shekau. Please welcome to this Thank you. We can see your hand waving. So permit Frank Tete to continue because in the bar, so that you don't go and remove the bar or the bench, so it won't go and fall. Permit Frank Tete to carry on. Please, Frank Tete, you still have the floor.
All right, thank you. So, like I was trying to say, there is no big deal in direct answer to your question with what has happened. We have all clamored for greater transparency.
Frank Tete, let me put it to you. That this act, from all the conversation that is on, I know you wrote a piece. Your piece is very fantastic, and that is a perceptional piece. There is the very core that the CAC can use some individuals within the church or the mosque or within the NGO to bring up cases that are not supposed to be. And then the CAC then step up to remove or sack or whatever to the board of trustees and then impose upon the institution, whether a church or a mosque or a non-profit organization on that. So are you telling me that's not true?
First and foremost, let's get something very, very clear. Very, very, very clear. CAC can only enforce what is in the constitution of the association according to section 825. Now, the most important thing is this. We must get this clear. For there to be an incorporated trustees, one thing that has changed is that CAC, before now, when you want to apply to be registered as an incorporated trustee, you will first of all apply for a name availability. And then when the name is available, you go and make a publication to invite objections that will be for 28 days. It is different now. What happens is that you will have to, in addition to the name approval, submit a constitution. It is that constitution that regulates the trustee. It is the breach of that constitution that will amount to a petition in most of the cases, apart from outright fraud being perpetrated. It is the breach of that constitution put together by the members of the association that is in question. So it is not about CAC coming from outside with its own standards. It is CAC coming to enforce the constitution that it registered, the constitution that was made by the members of the association, which ultimately translated to registered trustees. Let's make that very important point.
Frank, that's not new. That's not new. We've always submitted constitution. We've always submitted constitution as part of the registration process. That is not new. What is new?
The thing that is new, no, because what you are saying is this. What you're saying is that this fear that CAC can just take over an association, a church or a mosque, for example, is unfounded, because there must be an infraction of that constitution, and then there must be a petition by the members, either the members of the association or CAC itself, to a court that there are infractions, there are violations of the constitution and of the act before the court can appoint, the court can suspend the trustees not exceeding the period of 12 months for the purpose of correcting that complaint. And then it is not enough that 1/5 of the members will complain to CAC or to the court. They must have sufficient evidence according to section 839.
Okay, so which means, from your analysis, there's still the aspect where the CAC can organize, or the government can organize a few people in the church, and then or in the mosque, who, when the government feel uncomfortable with the leadership of that institution, whether a church or a mosque or a non-profit organization, maybe like us, an organization, a non-profit organization, an NGO, or the bar association, as it may be, and the government feel that the bar association is getting a bit, is going beyond what it should do. It can organize a few people, maybe like what's happening now in the bar, in the NBA. Can there not be a governmental, what we say in public administration, the divide and rule analysis, where you use some people against others? Can it not be what you are saying fundamentally is that Government cannot play divide and rule within an institution, maybe the NBA or the CDD or the situation or whatever organization or the church or the mosque, and then organize them in a way that attack your government, bring the fact, we're going to support you. Are you saying that will not work?
No, because the issue here is about property. It is about property of the association. Don't forget that when an incorporated trustee has been registered, the most important concern to the government is that the property, specifically the money of that association, must be used for the purpose of advancing the object of that body. Now, what Section 839 says is that, so when there appears to be a misconduct and a mismanagement in the administration of the association, and it is now becoming necessary to protect the property, that is the basis for the appointment of an interim trustee in the public interest, or to ensure that the association is not run fraudulently. So it is not about the government, it is about the purpose for which the association has been registered and whether its monies are being used for the advancement of the object for which it has been registered. It is not, in fact, it will be, from experience, it will be very difficult for government to take interest in an association unless the members, and I keep emphasizing the members, because it is now important for those associations to determine who actually their members are, because it is those members who can make such complaints of fraud or misconduct and mismanagement.
Frank Tete, there's been this conversation about taxing the religious houses, the church, the mosque, and even with the quest of raising money for the government. Let me quickly just stop there. I'm going to ask, ladies and gentlemen, this conversation is getting very thick. At some point, my distinguished, I won't say senior counsel because I'm not a lawyer, but my senior comrade, because Barrister Awa is a comrade, very recognized human rights, human rights, not just women focused. Awa is, in fact, I don't know which word to use, community-driven individual, one who has played many roles in terms of fighting for the very vulnerable people in the society. At some point, I would like to bring her on board to engage in this conversation. I'm not going to take her on the spot, but at any point she wants to interject or come in, I would duly oblige her to speak to this conversation. If you want to speak and there's a burning issue, question you have, please kindly notify by raising your hand. We'll recognize you that you speak, please, so that we don't end up getting a conflict meeting. If we all speak at the same time, actually nobody's speaking. And I want to thank you for the decorum that has been maintained so far. So now we are still on. Barrister, I don't know if you'd like to speak now. If you want, I will give you the floor. But otherwise, I will still face, okay, I'll go back to Frank Tete. Frank Tete, there's been this conversation about taxing the religious bodies, the church, the mosque, and even thinking about taxing the non-profit organization. Is this not a subtle way, you know, the dove, the snake kind of a process or techniques where you subtly in? Are you not seeing by your legal experience that this law is aimed to find a way to start collecting money, taxes or so from the religious body, particularly the religious body who has been in the front line of several controversy that the pastors have jeep, the bishop have jeep. Nobody talked about how they do it. And there's this accusation of non-profit now that the non-profit organization, they drive jeeps, they fly on aeroplane, they are in the US, they are in the UK, they are everywhere. I mean, people are just, let me get you back on this question. Are you not seeing the visible hand of demand and supply? Frank Tete.
Now, let's get something clear. In Section 839, one of the things that can constitute misconduct and mismanagement is with regards to the remuneration and reward of persons that are acting within the affairs of the association. It is believed that when the remuneration and reward become unreasonably high, that can constitute mismanagement. That is the reason why it is recommended at the outset that there must be a governing board, particularly recommended under section 836. There must be a governing council, a governing board that will now determine what salaries should be to the imam who is in charge of the mosque or the pastor. And then it's not necessary that if you look at the code of corporate governance for not-for-profit organizations as published by the Financial Reporting Council Act, by Financial Reporting Council, under the Financial Reporting Council Act of 2011, the certain persons like a founder and president, you cannot be founder and at the same time be president. You can only choose one, either the founder, you cannot not be president and then also be chairman of the governing council. And then all members of the governing council cannot earn any form of salaries or remuneration. Now, the goal of reporting, either publishing statement of affairs or publishing the accounts of the audited accounts of the church or the mosque or the NGO along with the annual returns, the goal is merely transparency. In fact, the CAC and the law recommends that after 6 years, all of those records in CAC will be destroyed. So they are not, it's not for collection of taxes. It is simply to show how the monies of the association, the money of the NGO, the money of the church or the mosque has been spent. Transparency, because CAC is a public registry. Anybody, any member of the public should be able to go to CAC and find out what the founder or the president of a church or the president of an NGO is. It is no longer that a regime of opacity. It is now openness, total openness to the public. So it is not for the purpose of tax at all. By the Financial Reporting Council Act and by the Corporate Affairs Commission Act, the one that has been repealed and amended, not-for-profit organizations, because they don't make profits, are exempted from payment of tax completely. So the issue of tax cannot come in.
Okay, yeah, Frank Tete, for the benefit of those who may not know what this section 839 says, it says it empowers the commission. That's, I'm reading from the new law, section 839(1), empowers the commission to suspend trustees of an organization, of an association, and appoint interim managers to manage the affair of the association where it reasonably believes that A, there is or a misconduct, mismanagement in the administration of the association. B, it is necessary or desirable for the purpose of 1, protecting the property of the association, 2, securing the proper application for the property of the association towards achieving the objective or object of the association, the purpose of the association, of the property of the property coming to the association. 3, for public interest. C, in the affair of the association are being run fraudulently. Frank Tete, 1 is fraudulent act. 2 is in the interest of public interest. Who determines the public interest? And very fundamentally, which I think you need to pay attention to, where it said, where it reasonably believe, which means the commission reasonably believe. Are you saying that where the commission reasonably believe is immaterial in this conversation?
You should have gone further to subsection 2, where it says that the trustees shall be suspended by an order of court upon the petition of the commission or members consisting 1/5 of the association. Now you should have gone further to say that it is not enough to say that CAC believes that there is misconduct or there is mismanagement or there is fraud. There is an application must be made to the court. But don't also forget, if you have your CAMA there, go to section 851. there is an administrative committee that is set up. It is not just CAC making up its mind that there is fraud. It's not CAC making up its mind that there is misconduct or there is overpayment or reasonably too high salaries being paid to the president or to certain workers. There is an administrative committee pursuant to Section 851 where these persons will be given fair hearing. The committee will be headed by the Registrar General or any other person with a lawyer that is above 10 years sitting in the committee as a secretary. Now, it is also important to know that no trustee, according to the law, no trustee, particularly I need to show you in a particular section, no trustee can be suspended without the approval of the minister in charge of CAC. In this case, the minister who should be in charge of trade and investment. So it's not a blanket power that has been given to CAC. The power is that whatever, first and foremost, there must be fair hearing according to Section 851 by an administrative committee of CAC, which is put together by the governing council of CAC. Then, for the suspension to be done, for the application of the suspension to be made to the court, the minister has to approve it. Has to approve the appointment of the interim management, and it is not forever. It is limited to a period of 12 months. So there is some measure of balance in this matter.
Okay, thank you very much. I have Babatunde Ladipo here. Babatunde, please, if you could on mic, and then you just quickly speak. I see you already. Just on mic, and 1 minute if you can quickly just engage. Yes, thank you. Please, what's the question?
Can you all hear me? Good afternoon, all.
I can hear you. Go ahead. Everybody can hear you.
I connected earlier, but my internet dropped me off, so maybe I might have missed something. As you read the, good morning, Frank, or good afternoon, Frank, I haven't even read it. As you read the law, 839, Section 1, and then there's Section 2. My question is simple. Can the CAC, management committee, whatever they are called, suspend the trustee of an NGO based on Section 1?
Good question. Good
Section
question.
2.
Good question. Frank Tete, exactly. Aladipo, you are supporting me because I'm waiting for Barrister Awa to come and support me because I'm waiting. Yeah, Frank Tete, you have the floor. Barrister Awa, anytime you are ready to engage, please kindly let me know. We'll quickly. All right. Frank Tete, you have the floor. Go ahead. Frank Tete, your mic is mute, please. Your mic is mute. Yes. Yes, your mic is still mute. Please on mic your mute. On mic your mute, please. Yes, go ahead.
Okay, let's get something very, very clear. Now, CAC forms part of the executive. So whenever any part of the executive known as the administration is exercising powers that resemble that of the court, it is therefore exercising discretionary powers, and as such, those powers must be guided by certain rules, one of which, most important, is fair hearing. So if you say that, if I want to answer your question directly,
please do.
On the basis of Section 839, subsection 1, can CAC suspend a trustee? The answer is no, because subsection 1 simply lays a foundation for the suspension and appointment of interim management, interim manager for that matter. So it simply gives the reason why a trustee can be suspended. Note, it can be one trustee or all the trustees. But all of this, that power, it is apart from the fair hearing that is required, all of these powers can only be exercised after the CAC or the members of the association have applied to the court. And then, for the purpose of appointing an interim manager, you require the minister to also, the minister of government to also be involved. So it's not enough CAC doesn't enjoy the wide powers to exercise such prerogative as it is said to be. The courts are there, and then members of the certain committee within CAC also have to grant fair hearing to the persons involved. So when there is a complaint, and if you look closely at section 839, it said upon, if you look at subsection 2, the trustees shall be suspended by an order of court upon the petition of the commission or members are present based on reasonable evidence, and such evidence must be requested by the court. So it's not enough to just bring allegations. There must be reasonable pieces of evidence for the court to exercise such powers. So there is one level of CAC, another level of membership, and then the level of the courts, and then the level of the minister.
You see, Frank Tete, what you have explained, well, I'm going to come back where I have someone else who is Kingsley. Kingsley was raising up his hand. I hope he's still raising up his hand. Kingsley. Kingsley, could you on mic, please? Ordering, please, if you can on mic. Yes, I see you. If you can on mic now. Kingsley, if you are still there, if you can on mic. All right, while waiting for Kingsley, I want to re-emphasize the comment made by Babatunde. What you are saying, I like, because this conversation is also aimed to counter disinformation associated with CAMA. And just for people to know, this is one of a special intervention from the Center for Democracy and Development, CDD, based out of Abuja. One of our intervention on passing the right information and ensuring that everyone has adequate information regarding conversation. So CAMA has been one of the most controversial conversation in the past 1 to 2 weeks, particularly from religious leaders and of course some non-profit organization. And just to know, one of the non-profit organizations has actually gone to court to challenge some of those provisions. So what Frank Tete, what you are telling us is that you can not implement section 1 without section 2 of the 839. Is that what you're saying?
It is not only section 1, section 2, but subsection 11. I'd like to read subsection 11 to you. The commission shall only exercise its powers under this section, under section 839, in respect of any association with the approval of the minister. You see, there's a balance. First, I need to re-emphasize this. I don't like this, you see, let us not cry wolf when there is none. Let us actually have a wolf before we cry. Now, members will complain to CAC that there is fraud, there is misconduct, or mismanagement. CAC on its own can observe from the annual returns that have been, from failure to file annual returns, from failure to file statement of affairs, and then make a complaint by inviting, again, section 851, inviting the affected trustees to come and make an explanation. After that, CAC can now apply to court, have these trustees suspended. Then section 839 also requests that those who are bringing allegations against the trustees must now bring sufficient pieces of evidence. And it doesn't end there. Subsection 11 now says the minister will have to approve. So CAC will not even attempt to suspend certain trustees or appoint interim managers unless the minister has approved. So these are layers of protection. We are seeking balance here. And let me be honest with you. From the experience I've had in my 15 years of practicing in CAC, I know that it will be very difficult for CAC to implement. We know how it is. We know how difficult CAC doesn't even, as we speak, CAC doesn't have the manpower to follow up on the numbers of the large number of registered NGOs, churches, and mosques. But it is when there is a conflict or there's a crisis that members will inform CAC. CAC doesn't want to be helpless in dealing with issues of corruption, issues of fraud, or issues of mismanagement of church property or mosque or NGO property. It needed section 839 to take some action. at least to invite them and then make applications to court, seek the approval of the minister before a trustee can be suspended and then an interim manager appointed.
But Mr. Frank Tete, you are talking to, lawyers are learned. We are educated, at least. I go school. In the English you are speaking, section 839 says, and it gave power to it, which is the commission, before section 2. And you are validating by your jurisprudence and your experience in the legal profession that section 1 of that 839 cannot act alone. But knowing the fact of a system that we live, we live in a system. This is in Nigeria where there's been controversial engagement in terms of application of court proceedings and all of that. Are you saying that the commission will not want to go ahead and apply section 1 first and stay there and hold there before going to court? Is that what you're saying? That will not happen?
Why should I speak as if I'm defending CAC? Today, AG Abubakar is the Registrar General of CAC. We were friends when he was Director of Compliance, but since his RG, we have not been in touch, and there's no basis for me to actually go and meet him because I no longer register companies or incorporated trustees. But there's one thing: the expectation is that AG Abubakar, as a very senior lawyer, and a number of all those my friends who are lawyers in CAC that are also familiar with the bar chairman, I expect them to go by the mantra, by the motto of the NBA, rule of law, ubi jus ubi remedium. That is, we should advance, we should expect that they should be compliant with the rule of law. AG Abubakar was for a long time, AG Abubakar is currently the Registrar General of CAC, but for a long time, he was Director of Compliance. His work was to ensure that every aspect of the CAC, the Corporate Affairs, the Company and Allied Matters Act was complied to. He did a very good job when he was Director of Compliance. We are going to watch him very closely now that he's RG and find out whether he's also going to ensure that he complies to the law. See, I have given you the levels, the different levels of protection against an arbitrary application of the powers of section 839. CAC cannot on its own do that.
Okay, I see Kingsley. Kingsley, if you are there, you can unmute. Also, Olumesi Akigbe, if you are there, if you can also unmute. Yes, Akigbe, I see you. If you can unmute and if you can engage quickly, who is going to go first? Is it Akigbe, Olumesi? Are you going first, or is Kingsley Ebediren? Who is going first? And okay, while waiting for any of them to go first, the Enoma has asked a question. How do you juxtapose getting a court order and getting the minister's approval? Are you saying that getting a court order, CAC must still get the minister's approval? Is that what you're saying?
Can I? Okay, thank you, Eno, for that question. Because of course, you see, that's a very practical way to look at it. Now, my happiness about these provisions is that there are these serve as checks. So it's going to be very difficult to see that CAC will be appearing to act alone. The moment it gives the semblance that it's acting alone, you can write a petition to the minister. But there is going to be an assumption. There is going to be an assumption that each time CAC approaches the court, it has already secured the approval of the minister. I'm going to believe that there is going to be an assumption. But I'm happy that there is at least a provision in subsection 11 requesting that the minister must grant that approval. I am also thinking, and will be dangerous, that the minister might waive his approval and grant the minister for that period might grant an omnibus approval, that is a once and for all approval, that whatever you have my leave, you have my approval to proceed whenever you think fit. But whatever it is, the minister, at least, the minister, he has some role to play.
Okay, so I have Oba, if you are there, you can unmute. You can unmute and speak directly. Kingsley, I still have you. I have Orumesi Akigbe. Either of you want to speak first? Go ahead. First on mute, can take the floor. Uba, who is going first? Kingsley. Kingsley, you are speaking, but your mic is mute. On mute, please. Kingsley, please unmute. Okay, Kingsley, I just can't. I can't. I'm trying to help to unmute, but I think I have a challenge. Maybe it's Kingsley, you have to unmute yourself because no one is hearing you. You are speaking. I see that you are speaking, but no one is hearing you. Uba is also speaking. Oh, there's a challenge. What's happening? I hope that CAC has not unmuted everybody. Just kidding. I think there's a challenge. People are trying to unmute and it's not happening. I see that Uba is also speaking. And hold on, guys. Let's try to deal with these technical issues.
Yeah, can you hear me now?
Yes, we are.
Okay, thank you.
We are hearing you.
Let me quickly just say this. It is an act now, and section 839 does not appear to have made.
Kingsley, can you hold on, please?
Okay.
Kingsley, can you hold on, please?
Yes,
Let's
I
hold
can.
on so that we are back. See, we are back. It was a technical challenge, but we dealt with it. CAMA will not stop us from having this conversation. Frank, please listen. Kingsley is going to take the floor first. Then I'll move to Akigbe. Then I will then take Uba third. Please, 1 minute, please. Kingsley, you have the floor.
All right. Now, section 839 does not appear to have made subsection 2 to flow from subsection 1. So unless the cost do an interpretation
please,
of that.
Everyone, kindly mute yourself, please. Kindly mute yourself, please. Kunle, please. Adanu, please mute yourself. Adanu, Moses, please mute yourself. Kindly, please mute yourself because we are trying to deal with the technical issues. Please, Barrister Ability, kindly mute yourself as we move. Please, Kingsley, go ahead.
Yes, subsection 2 of this section 839 has not, is not a continuation of subsection 1. So subsection 1 can actually be taken independent of the other subsections. That's one point. Then the second point, whenever issues like this, we're in a secular Nigeria, we have a secular government, and we must not lose touch. We must not be oblivious of the environment we are. We're in a country where the independence of the judiciary is in doubt. We are in a country where we know INEC is not independent. And if you look at subsection 1, it doesn't make reference to court order.
Internet is, yeah.
It doesn't make reference to any court order.
Okay.
So that means the
thank you very
commission
much.
can go so moto. Yes, the commission can go so moto. And
yes,
anybody can be minister. What if there are motives? Once there are motives, whatever committee who pays that administrative committee that approves the setting up of an interim management committee for a church, a religious organization. We're in a country where you have two competing religions, where there is mutual mistrust between these religions. Now,
all right, I can hear you, Clemoto. Yes, so that we can.
Yes, what is wrong?
If you can conclude
the existing laws. Yes, I want to conclude now. The existing laws relating to fraud and lack of problems of accountability, if they are utilized to ensure there is accountability in NGOs. Then, lastly, if that section can be amended so that there must have been a court judgment, a court, the stability of a religion, we don't even to be found wanting or not. But it's a religious organization where they are involved in spiritual life of members. So that is it. There are no guarantees at all that the CAC will be above board. In fact, it's not even necessary at all for all our eggs to be put in the trust for CAC basket. Thank you.
Thank you so much. That's a fundamental question. I think you got up back to where we are. Babatunde will be smiling at the comment you just made because the answer there is not so clear. I'll take the next question. Who is available is Akigbe. Please, can you go ahead? Akigbe, message. Akigbe, message. You are still mute. Oh, you still cannot admit. Please, Nena, if you could let people have control of their microphone, please. Okay, so while waiting for the next, Tete, can you respond to Kingsley's postulation?
All right. Interestingly, Kingsley has shared this position with me before now.
Call Israel to help me call Nena. She's muting people. And the way it is now, she has taken over my rights as host. I'll not be host again. I don't even know how to get back my hosting rights.
Can you listen to me? I can hear you.
Okay, please go ahead. Go ahead, please.
All right. Now, Kingsley has said concerns to me. As lawyers, we know that we don't read in interpretation of statute. It is only when the application of strict construction approach fails to meet the goal of the act that will now apply the rule. If you look at section 839, subsection 1, I want us to look at it again. By hear me.
Please, if you can mic your microphone. Afolabi, Ebun, kindly mute. Ebun, kindly mute your mic, please. Ebun, kindly mute your mic, please. All right, Frank Tete, go ahead.
If you, if you look at, because we need to have this in conversation. If you look at section 839, the commission by order. The question is which order? The commission make an order? No, the commission cannot make an order. If the commission can make an order, why would subsection 2 refer to order of
Why did subsection 1 not make reference to order of court?
No. Wait. Please.
Okay, two of you, if two of you continue, I will ask my senior counsel so that we can have this conversation very interesting. Barrister Awa, please kindly intervene in this conversation, please. Yes, Frank Tete, go ahead.
So what's important is this? Clearly, go.
Please, a moment from now, I'll give you the money. It's not like forget.
Hello, dear participant, please. See, we're having a challenge, technical challenge. That's why we're unmuting everybody. Please, if you are not speaking, kindly mute your microphone. It will help us go faster. Please, we beg you so we can go. This is more of an intellectual conversation. Kindly mute your microphone. Let's get this conversation ongoing. And we'll see. I'm coming to drag my honorable chair to this conversation. Barrister Awa Shekau, please get set. You are going to intervene in this conversation very just now. Frank Tete, you see at the floor. After you, I'll go back to Barrister Awa.
No. Simply put, the goal is, and the goal is this. There are 4 layers of intervention before and CAC cannot do it alone. CAC cannot make an order. Others proceed.
Man, oh my God. I don't know what we are going to do. I may be forced to remove people from this conversation. I'm avoiding not removing people, but kindly mute your microphone because one individual cannot.
Don't you mute everybody now?
Festus, if you mute everybody,
yes.
By the time one person wants to speak. Nena, if you can hear me, please mute everybody. When I request for this thing, please
yes,
return
that's
everybody.
Better.
All right.
Better.
Nena, you have to be with me on this conversation, please. All right. Mute everybody right now and release my Frank Tete.
So the point is this. I understand the fears that the excessive application of powers by CAC. CAC does not have the capacity by law. CAC does not have even the physical capacity to be, investigating justice. For that effect. You also require the approval of the minister to remove trustees or managers. You also require the approval of the minister to transfer the property of any NGO, church, or mosque to any other one. So the powers of the minister, and it is expected that it is our vigilance that will prevent any abuse or arbitrariness. It is possible, but we all know now, we're having this conversation and we are taking the stand that subsection 1, subsection 2, and subsection 11, CAC on its own cannot remove remove trustees and appoint interim managers. Let us rest that matter.
Okay, so I want to bring in my very senior counsel, Barrister Awa Shekau. Please, we need you at this material time. If you could oblige us this very rare opportunity, please. Even if it's just to speak, Barrister Awa, can you unmute your microphone? Okay, good. Please go ahead, Barrister Awa. Just for people to know, Barrister Awa is the MBA chair, the chief president, chief chair of the MBA in Abuja. For you to know where the knowledge will be coming from. Please go ahead, man.
Which knowledge? All right. Good afternoon, my learned friends and colleagues. I thank you for this opportunity to speak. I think I must confess that at some point I dropped off and didn't quite get a lot of the conversation. Also because I had some guests coming in and out of the office, so I was a bit distracted. And regarding CAMA, on a very, very serious note, I must confess, I am yet to study that document. The Nigerian Bar Association Unity Bar is already working closely with the Corporate Affairs Commission. We are planning a seminar that will bring CAC, ourselves, and other respected colleagues who have expertise in this area to discuss the different issues. I was so interested in listening to Frank Tietie and what he had to say around the non-governmental organizations as well as religious bodies, because these are the two key stakeholders who have raised a lot of concern about the new CAMA. Now, what I discovered was that most of the copies that are flying around is not actually the gazetted copy. They are yet to gazette it. And from what I gather, we reached out to the National Assembly. They are hoping by the end, before the end of this September, they will bring out the gazetted copy. So I am a bit skeptical about making comments in respect of a document that we're not even certain if some of those sections actually sails through. So I think whatever our concerns are, we may need to sheath our sword and wait until the gazetted copy is out. It is that gazetted copy that would then be the main act. And then, we then know what the next steps are going to be. But definitely there are concerns out there, especially amongst religious bodies, because, power without control is something that can easily be abused by human beings. In fact, power without control becomes a dictatorship. So how can the, whoever the regulatory body, that is the Corporate Affairs Commission, for them to be able to intervene whenever there are, some situations in a non-governmental organization or religious body, there must be a strong reason for their intervention. And when they intervene, what is the limit of their power? What can they do? It cannot be left at the whims and caprices of the commission. Then anybody can just go and just foment trouble simply because they want the Corporate Affairs Commission to take over, that organization. So I can understand some of the concerns, but again, we have had stories of some faith-based organizations going into so many areas such as money laundering, terrorism, and what have you. How then do you step in to stem, those kind of activities? So whichever way you look at it, there are arguments both for and against. So it's a matter of us profiling, ideas on how we think it will work effectively. And like I said, I think we need to get that gazetted copy and be very certain what was actually passed and signed into law. And then if there is need for a review, then it is also, it will be an opportunity for us to look at it and then propose some review. I can assure you that the NBA Unity Bar is working on this very, very assiduously, and we'll definitely work closely with other key stakeholders to see what we can do to improve the situation. I thank you very much for the opportunity. I thank CBG, and I thank Frank Tietie for his zeal and commitment in advancing the frontiers of knowledge, particularly around this issue. Thank you.
So, my chair, before you mute, this conversation is not over. Will you want to get us back that information? Will you want to engage with us next week, Tuesday, so we can take this conversation further?
Very well, very well.
Okay. So, ladies and gentlemen, we have a guest for next Tuesday, same time at 2 p.m. Barrister Hawa will be coming live with the gazetted version. But right now, let's continue with our conversation.
The gazetted copy is not under my control. If it is out at that time, that would be my pleasure.
Okay, we'll follow up the conversation with you before next Tuesday to see if we can get that copy, because we need exactly what is in the document that is gazetted. We thank you for that information you have provided. So let's go back. I have Akigbe. Please, Akigbe, you have the floor now.
All right, thank you very much, everybody. I said I just want to add my own contribution to the discourse. And you see, the whole issue about CAMA has really shown how our legislators and our lawmakers take Nigerians. These laws and these things they try to project in this new bill. When they were doing the NGO bill, there was a lot of people, a lot of NGOs and everybody came out to say, no, this law is not a good law. Because they saw that they couldn't push it then, they stopped it and decided to pass it through this CAMA. They brought most of those things they wanted to control in those in the NGO bill and put it in this new CAMA. And that is why the same agitation, this time around, they did it in a way that the public had no opportunity of people making any input. Before you know, it was already a law. Before you know, it was already signed by the president. And up till now, we don't even have a gazetted copy, as the Unity Bar is letting us to know. That tells you the intent of those who promoted this law. Their issue is clear. They are trying to make sure that Nigerians are not able to check their excesses. So if an NGO is very active and is checking their excesses, they will quickly activate these clauses they've brought into the law. And before you know, they have messed that NGO up. Your voice to check them, you've lost it, because just before you know, let me tell you, all these check-ins, all these layers, Mr. Frank is talking about, they are very good in developed areas, in countries where institutions are respected. You can say that. But in Nigeria, I'm telling you, within a twinkle of an eye, all these layers will be exhausted, and before you know it, that organization is replaced. Look at the Edo case that involves Obaseki. Within 2 days, there was a judgment to disqualify him. There was an appeal. These are committees. Professors even headed this committee. That's to tell you the level. The minister, even the CLC head, all of them, they are appointed by the state. So if the government or the interest in government just want to deal with an NGO or a church, within a click of an eye, all the layers will just say yes.
Okay.
And such organizations. So that is why I'm not happy, because this all those guys, all those.
Thank you. You can summarize, please.
Controlled by them, and within a twinkle of an eye, all of us will be in trouble. So it's not a law we should allow to stay. Gazetted or not gazetted.
All right.
We
Thank
should
you.
start attacking it now, so that they will not even gazette it. When they are bringing the gazetted one, they will even try to reduce it before they even bring that gazetted. But since we don't even have it now.
Okay. Thank you. Frank Tete, I wanted if we could take the last question or the last comment from Oba, so you can just respond. Oba, please go ahead.
Okay. Good afternoon, everyone.
Good afternoon,
My
madam.
about three. The first is that I wouldn't know if Mr. Diete is aware that the charities in the UK are so regulated because the government contributes makes up a portion of the funds that is used to regulate that is used to operate the charity. So that is why the government made such laws that the Nigerian legislatures copied from the UK and are made applicable to the Corporate Affairs Commission, Corporate Affairs Commission and corporate organizations and NGOs in Nigeria. So I wouldn't know what he can say concerning that. And also, I don't think it is true that the CAC lacks manpower to carry out or to enforce these laws as passed by the National Assembly, because we have seen a CAC who carries out directive with the little manpower that they have currently Just in a few months ago, they decided that you must get consent before you now register NGOs. They use the manpower that they have. So this same CAC, I believe, can fully implement these laws, the Section 83 and other laws that are concerns to Nigeria, without even increasing the manpower that they have. And as rightly pointed out by the last speaker, the minister, the CAC, the courts, they are all appointed by the government. So what they need is just the very organization that, or the religious body that they are concerned about. Once they get that religious body, they gag up the religious body, use the machinery of government and shut down that leader or whoever it is they want to shut down. And also, I would want to know what his thoughts are on the fact that some people have proposed out there that if you know you do not want to be regulated, go and deregister. What is the possibility of having that happen in Nigeria? And when such happens, how can those organizations and their members be regulated? Thank you.
Okay, fantastic. Now, Frank, you have the floor. 3 straight questions. I know you already technically responded to that of Kingsley, and I'm proud that Barrister Awa intervened too. But we have 2 questions now before you, even though the question on Edo disqualification of Obaseki is not in the court. That's just a political party affair, as Akibe has earlier raised. So, Frank Tete, you have the floor. Now, these issues have come back again. The charity in the US, and they said that was a very strong indictment. You mean our legislators are copying? Is that not plagiarism? Frank Tete, go ahead.
As we speak today, more than half of our laws are copied. It's a normal thing. We were once a British colony. All the laws in England as at 1900, January 1, 1900, were all taken into Nigeria, and many of them are still there. We still have those things that are still very irrelevant laws. The laws that regulate the will today, the Wills Act, and all of those laws are laws and laws. There's nothing wrong in borrowing.
I'll be forced to remove this David Crown. All right, please go ahead. If you are not mute, I'll be forced to remove you this material time. We ask that everyone should mute so we can have conversation effectively. I have someone whose baby is behind the scene. If you could please mute. All right, please, Tete, go ahead. Sorry for this breaking transmission.
You know that as a lawyer working in the development sector, I work for an NGO, and in addition to my private practice, and there is a question that needs to be asked. My concern is, why shouldn't we be bothered about the proper things, the things that are actually troublesome? The goal of my intervention in writing that article, which was widely published by the Punch and the Vanguard and the Nation newspapers, is that I want us not to bother about something that is non-existent. The fear that is associated with Section 839 is non-existent. Many of the fears associated with this new CAMA are non-existent. And I think there are greater issues. The question to be asked is, who is afraid of transparency? It's not about control, it's about transparency and accountability. Now, I want to address some of these questions. The last speaker spoke very directly and very well. And I must thank the chairman of the NBA Abuja branch for those remarks. But let's get something clear. Not only in the UK, but even in Nigeria and elsewhere, charities, NGOs and churches, in Nigeria they are called faith-based organizations, have the right to apply for government funds if at all government make available those funds. It's unfortunate that we hardly see government through the National Planning Commission making available certain funds for NGOs to apply for. Recently, I got wind of the Ministry of Budget and Planning requesting for NGOs to make application for certain things or the other. So NGOs can have access to government funds even in Nigeria, just like in the UK. Now, I made my point clear. There is nothing wrong in borrowing laws at all. So there was nothing wrong. It only shows some measure of laziness on the part of the members of the National Assembly who don't want to generate, homegrown laws, but they just go to the UK and take a law, because the UK has existed much longer than our country. Now, let me tell you what the problem is. In the northeast of Nigeria, where I had gone to do some training for the UNDP, I realized the NGOs have a very bad record. NGOs have bad record with the army, bad record with the government, not because they are bad, but because certain persons fraudulently used NGOs to collect those huge amounts of monies that were meant for development and relief efforts in the northeast. Now, you all heard about that Abuja-based pastor who got over 570 something million naira paid into his account. Now, paid into church account. Now, what the previous law, because Kingsley Akwedin, a very brilliant corporate lawyer, had made reference to the fact that nothing was wrong with the previous law. The previous law, in the annual returns form of the previous law, didn't request you to attach audited accounts. If you have 575 million naira paid into church account without explanation and moved from there, converted to dollars, and then paid for one kind of reason that nobody explains, you will be called to explain. So now, I want to address that issue when I say CAC didn't have the manpower. I practiced for a long time in CAC before I went into development practice. Now, you know CAC still operates manually. All the time you go there, they still tell you that they have server issues. They can't even guarantee server that works 24 hours. Now you want to talk about tens of thousands of registered NGOs that still have manual files. They've not even scanned the documents yet. Though this new law mandates empowers CAC to request all its registered bodies to now send in scanned documents so that you can access these things electronically. CAC doesn't have that manpower, I know, because it still operates. When we go to CAC to do search, you still wait for if you apply a day before, the next day it is given to you, and then you still go through with manually by checking page by page. It's my country, so I don't want to be ashamed of it. But the point is this: I don't think, as an activist, I belong to the NGO community. I think it doesn't speak well of us that I belong to that community, and we are crying that there is a problem where there is none. The goal is transparency. The goal is not control. Nobody's interested in controlling. How is a Muslim interested in controlling my church? What is he going to gain? And by the way, finally, in this round of questions, do you really need an NGO to criticize government? If I praise government today, I praise government for signing CAMA, because I know the abuses that have been associated with running NGOs and churches. I know them. I don't want to mention them. But I'm against the water resources, the National Water Resources Bill. I do not praise the government for that. I will attack the government as an individual. Finally, the honorable chair of the NBA talked about a gazetted copy. Yes, that is the authentic version indeed. But you know what happened? You can't expect this controversy to be on, and then we don't have anything to look at. So I went to the National Assembly, went to the registry, went to the library, and demanded for the clean copy. This is not a gazetted copy. I demanded for the clean copy, and I was given the clean copy, and I made sure I circulated the clean copy so that let us have something. We cannot just be discussing in nebulous and building something out of nothing. So we have a clean copy, and let us allow this law to operate. The property of a church or mosque or NGO, we don't care how much the president of the council earns, but let it be known that you earn so much, so that your members can be well guided on the way they make their donations. When they make donations thinking that it is meant for the church missions, yet it is used for buying Rolex watches, or it is used for vacation in Dubai, that's not proper. I cannot be an anti-corruption crusader and allow opacity in running churches.
Okay, Frank Tete, you have gone beyond.
I would like to speak.
No, Kingsley, before you speak.
Moderator, sir.
I
would like to also make an intervention.
Who is that, please?
Festus Omoregi.
Oh, Festus, you have not raised your hand.
Yes.
Please, just hold on. I have Kingsley, Austin J.
Okay.
If you could just speak, I will take Austin J. I will take Kingsley. I will take Omoregi.
Yes.
Austin, go ahead. Austin, you have the floor.
Thank you so much. I've been listening, and allow me to stand on existing protocol. I just wanted to make one or two contributions. Can you hear me?
Please go ahead.
Can you,
we have limited
Yes.
time.
Can you hear me?
1 minute to just. Yes, we can hear you.
We can hear you. We can hear you.
Yeah, well, yes. All right, thank you. I just wanted to ask, why is it that there's the allegation that those provisions were smuggled in? Were they not part of the original draft? I don't understand that. So if somebody could answer that question, I'll be very grateful. And then number two, even though yes, we should have laws that are regulating NGOs, etc. We should have that in any civil society. But if you look at section 8391, it is practically draconian, because where it says that the commission may, by order, intervene, etc., it means that it does not need an order. It can decide to do it on its own.
Thank you. Somoto. Thank you.
Issues with it.
In fact,
all right. Anyway, those are basically the two issues that I want you to look at. I'm told I have limited time, so that's just my conclusion for now. Okay. I'll be grateful if somebody could respond to that. Thank you.
Frank Tite is going to respond, yes, but let me quickly just manage that thing for you. It said subsection 1 of 839 empowers the commission to suspend trustees. So so that I don't belabor, Kingsley, hold on. Omorege, please, if you can quickly go straight to your question.
Okay. Okay, thank you very much, moderator, sir. And I really want to appreciate everybody, particularly Frank, for the very brilliant elucidation that has been made. And I also want to stand on the existing protocol. Now, I am a pastor, so I am also very much interested in the aspects that has to do with regulating churches. But I want to say this, that I think there are just two key issues here that we must look at, dispassionately. One, our government has a reputation of not being trustworthy. So is a trust deficit that is actually the problem here. Not that in itself, this new CAMA Act is really a bad law, as it were. It's just because we don't trust the motives of government, because our government has never been, known for doing, even see that, upright about the intention of this new act. That is on one side. Then on the side of the churches, I think, this is also a wake-up call to us as churches. I'm a pastor, like I said, even though my church is yet to be fully registered, and we are working towards that. The truth of the matter is that the reason why churches are having this, concerns is because they have also deviated. I'm not here to indict any church or any ministry, but the scripture is very clear. If you read the book of Acts chapter 6, where, the first, where we saw in the Bible that the first time that officials of the church were appointed, as a matter of fact, the Bible told us that because the number of the disciples multiplied, and there were, quite, a mixture now between the Jews and the Gentiles, and there was a need to properly handle the business of the church. That was when trustees were first appointed, even though the Bible called them deacons, but they were actually trustees. And if you read specifically, the apostles then said, look, you should look out for among you men who have the Holy Ghost, men of revelation, men of wisdom, men of honor, to look over this business. And what was that business? The business of handling the material affairs, material activities of the church, so that we may give ourselves continually to prayer and to the ministry of the word. But today, you now see that pastors have left, the responsibility of the ministry and of the word and prayer to dabble more into business. And that is why you see that these pastors are listed among
the issue should be addressed.
Yes, I'm trying to address the issue. If pastors will self-regulate, if the churches will really self-regulate themselves and not do the things that will make the public lose confidence in them, then it will not, there will not be any reason for this, because where there is no offense, there will not be any punishment. If churches are run transparently, just like as it ought to be, and everything is done properly.
Pastor Festus, I want to quickly ask you one question before you go ahead.
Yes,
are you aware of this Krumel?
Go ahead.
Are you aware of this Krumel?
The Krumel.
Yes.
Yes, this.
So what's the difference between, because every money that comes in, that goes out, because people talk about the churches or the religious houses trying to use money to finance terrorism and all of that. Are you aware that, there's already structure in place? Because one of the things like Akigbe raised, one of the accusations that led us to fighting the NGO bill, we felt it was repetitive. There were already existing laws that were to tackle those issues, implement those laws that exist before coming up with a new one. But right now, you are unable to implement an existing law. Why in a hurry, when there was already conversation on attacks on religious houses and all of that, and then suddenly there was a boom, unknown? Were you ever aware of a public hearing on this new CAMA Act?
No, I wasn't.
So, like you, many more on this platform were not aware of a public hearing, whether public hearing was ever held on the new CAMA. So the question is, why would you already put together an act and now you are even wasting, you have taken much time to gazette. Ijoma, my friend, has just wrote that it's going to take about, by the end of the month, to get a gazette copy. So,
moderator, sir, you see, the issue is that we are having, we are hearing all these protests because there seems to be a well-structured plan now to deal with what has been going wrong. That is why we are responding. Not that we are not aware, not that those other acts or laws were not there, but they have not really been implemented properly. Yes, you can say that, why don't government go back to that? And I also support that, yes, government could also use the same process of courts to deal with issues of infractions, by NGOs and churches. But the point still remains that, sir, with all due respect, is that if, no matter how bad the intention may be concerning this law, if churches would run and public organizations and NGOs would really, self-regulate, run their affairs as much as, particularly with churches, because churches have a higher moral ground to stand.
Yes.
All right, Pastor Festus, if you could summarize. Yes, thank you very much.
That's just my point. That I think that we also have a trust deficit on the side of the churches. That is why you see even a lot of members of the public, apart from the pastors, a lot of members of the public are happy about this law. And that is enough reason for us to sit back and reflect on why is it that many people in the members of the public really would want this to happen. And you see the protest.
Pastor Festus, I want to believe that that's perception. That more public
perception.
Yes. So, Kingsley, 1 minute.
Yes.
We have just 5 more minutes to go, except we agree together to have more 10 minutes to go because the conversation, so we can agree on what next step to take.
Yes.
Kingsley, you have 1 minute.
There are two issues here now: accountability and control. I personally don't have any problem with accountability. If the annual returns or whatever the CAC requires, documents or returns or information the CAC requires from non-governmental organization, all well and good for accountability. But the issue of control, where an institution can exercise discretion without discretion over non-governmental organization. Of course, subsection 1 doesn't talk about any court order. And even if there's court order, we are saying that all those processes can still be abused. There should be sufficient balance so that no institution can abuse the process. The current section 839 does not guarantee that. And even on emphasizing the integrity of members of CAC and others, it actually see that as very watery, very watery. You cannot depend on the recommendation of individuals as the guarantee. The actual words, the actual construction of the section provisions of the law should give us those guarantees. And there are draftsmen that can do all that. So the lawmakers are just lazy. They have put in place a potential monster, The wording of that subsection, of the various subsection and sections of the new CAMA can guarantee that the process of control cannot be abused. That is it. Thank you.
Okay, thank you. I do appreciate that strong comment. Frank Tete, there are some questions. Please, there are people who need somebody wanted to find out. Mayon wanted to find out from you if he said it's Duke from CCJ. I'm sure you know him. He wanted a clean copy. If he was asking about clean copies from the National Assembly with you. Another question is from Joshua Benson.
Hold on. Duke just got me there. What Duke was asking there is that, was the clean copy certified by the official of the National Assembly? That's what Duke is asking, and Duke knows the answer. He's asking for a specific purpose. The truth is that it's not certified, and you know what it is to get documents certified in that regard. If you want to know, I actually did some extraordinary things to get that clean copy. I was convinced that it's a clean copy, and it's not different from what my other senior colleagues in the NGO sector had. But I wanted to make sure that it came out from the National Assembly, and I got it. We just needed to have it as a document.
A working document. Yes. Okay, so I have this from Joshua. Okay, maybe based on this information you have shared now, Joshua has put up his email here. I'm sure you can see if you could get him the copy, or until when the gazetted copy is available. As Barrister Awasheka has earlier mentioned, we still don't have the gazetted version. The same president who removed several electoral acts. So again, these are the contentious issues. There was an electoral act ahead of the election which was not signed, and everyone wanted that be signed. It wasn't signed, and we're back again to a constitutional review. And meanwhile, a CAMA orally, whether it was in the 90s, it was passed, I don't know. Let me know in that National Assembly. But
let's get please, let's get something clear.
Were you part, Mr. Tete? Were you part of the public hearing of the new CAMA? Did you ever?
It took 3 years. This CAMA, the Company and Allied Matters Act, had operated for 30 years, but it took 3 years of this assembly. In fact, many assemblies have been working on various amendments before, but this particular amendment and repeal and reenactment took 3 years to put together. I'd like to respond to what my friend Olumese referred to. You know, in law, we talk about those who come to equity must come with clean hands. And then, a very common English proverb says that, expression says that a clear conscience fears no accusation. All of these, and then
quite naive.
Please, hello,
with due respect. With due respect.
Well, it's okay. Now, the point is this. As a practitioner myself, and with eschewing politics, we know that I don't think we should continue to hold this fear, because it shows us as people who are unnecessarily alarmist, and as those persons who want to create tension when there is none. It will be very unfortunate that a lawyer who understands that every act of the executive in exercise of discretionary powers or administrative duties, functions, is subject to judicial review. It will be very wrong for a lawyer to be the one creating trouble, stirring up troubled waters. I maintain it again and again that
12 months.
No, please, Kingsley, can we have the conversation on, please?
All right.
Kingsley is not a practicing lawyer like I am. I know for certain that every act of the administration, the whole body of administrative law is set up to regulate, to delimit the powers of the administration. I have said in clear terms that the section cannot be mentioning court order and approval of minister, and a lawyer would say that no, CAC can on its own go and make an order. That is very, very doubtful, and it's unfortunate. I maintain, and those who operate CAC know better, I do not endorse AG Abubakar, but when he was in compliance as a practicing lawyer in CAC, he did well as a compliance officer. Now he's Registrar General. I expect that he should follow the law. I do not expect AG Abubakar to preside over the administrative committee and suspend a trustee without giving a trustee fair hearing. The principle of fair hearing is so sacrosanct. I don't expect a lawyer to come and say a decision will be taken concerning somebody in Nigeria and the person will not be given an opportunity to make a representation. That is very faulty.
Okay,
I want to remind all.
The
Finally,
question about Kingsley, Austin's question, please. You remember?
Which question on Austin?
Yes, Austin asked a question. I forgot. Austin, can you type your question again? I think.
Okay, I know. Okay,
where I talked about 839, section 1 was smuggled into a new act. At what point was it smuggled in? It's been 3 years in work in progress. At what point was one? Yes.
Let us restrict ourselves to what we know. Before I answer Austin, there's that young woman that talked about those who wish to deregister. I made it clear in my article, and that section 40 of the Constitution empowers any group of Nigerians to associate, no matter how few or large, without registering with CAC. And they can as well apply for dissolution if they so wish. And then but they must go through all of those funny procedures of accountability for the property that it has. You do not need to be registered. And that's one very painful aspect. As I see it is a do or die thing. You do not need to be registered as a church, a mosque, or an NGO. In fact, you can gather yourself and say, and just like we always have, Association of Concerned Nigerians. You don't require registration, and they have made even more impact. Look at the Save Nigeria group, for example. It has made greater impact than many of the NGOs that have been registered. Then, so let's go back to Austin's question. I cannot tell whether certain sections were smuggled in, but I do know, because at present I am criticizing the National Water Resources Bill. It's a bill at this moment. Now, because I'm in touch with some members of the National Assembly who told me personally that this was not the original copy that we agreed to. So in that case, you can now begin to raise allegations of smuggling in of bill. And that's why Mrs. Shekarau's statement regarding the gazetted copy is important. No legislature yet, no senator, no member of the House of Representatives has yet said what we have now, it has any section that is smuggled in. Those who operate the company's aspect, part A, are very happy with the fact that one man can now register a company. Many lawyers are happy that you can now have limited liability partnership. But those of us who operate in the development sector, some of us, the school of thought which I belong to, is happy that there is now greater accountability, greater transparency, and there is nothing has changed with regards to control. You are in control of your church, you are in control of your mosque and your NGO because you made the constitution. And it is actually those members that can complain to CAC. I thought we should be more concerned about membership. I want to remind us of something about the NGO bill that we fought. The NGO bill that we fought was to create an NGO regulatory commission. It wasn't for the purpose of expanding accountability or reporting standards. No, it was about creating another commission. I was at that time campaigning that, in fact, the Financial Reporting Council can do the job that the NGO, the Regulatory Commission can do. And I also said that CAC, in fact, can do that. And I maintain that for those of us who have nothing to hide, we are not afraid to report the monies that have come in and the monies that have been expended. And we say it clearly, no imam, no Muslim president or Muslim registrar general can come to my church and tell me that he's interested in removing my pastor or removing the trustees. Nobody is interested in that. When it happened in the UK, when the trustees of the Mountain of Fire and Miracles were suspended. The Mountain of Fire and Miracles didn't cry that unbelievers have taken over our church. No, it didn't happen. Because the goal was simple. The UK Charity Commission said, you haven't filed your annual returns as you should. So there are problems with regards to your accounting, with regards to the amount of money and your property. So we are going to appoint an interim manager to collate your property, your records for us, your church worship, your whatever freedom that you have to preach or to do whatever you want to do to advance your aims and objectives. They cannot be affected at all. Why should we be operating in a sector and allow this kind of ignorance to prevail? Set the whole place on fire in tension when nothing has happened. We should rather face the real issues. And I like the fact that some persons have pointed out that the real problem is not in the law, but persons who are likely to operate the law. Is it because we have a Muslim president today and we have A.J. Abubakar as a Muslim who says that Kingsley Akpeliri cannot become the Registrar General of CAC tomorrow, and then a Muslim will start crying that Kingsley is interested in taking over the mosque? Why should we unnecessarily heat up the polity? Enough of bad governance, but we as citizens must not, out of ignorance, now contribute to the tension, to creating tension when there should be none.
Okay, so I think that it has given us a good flesh for the next episode between regulation and accountability. Because regulation, accountability, and control. So that regulation and accountability works together. Because I think, in all honesty, I'm not too sure people are afraid of regulation. When, the lines of the law, I read public administration, and by that privilege, I also understand a bit of administrative law. So the lines of the law affect a great deal to some degree. Let me use the word. My position at the beginning of this conversation was, does section 8391 and all of them, subsection 1, or standing on 1 totally, section 1 and section 2, at what level do they correlate? Because if they can act alone, Kingsley has supported me in that argument, that it was possible for that section 1 to act alone. But Frank Tete, you tend to differ, that section does not have the capacity to act alone. And Austin also brought out that dimension. That at what point was that brought in? The commission having the powers without, first of all, recourse to the court, without, second of all, complaint from the members of the church or the religious association, the commissioner having the power to just intervene. That's a question that we must interrogate. We must continue to interrogate that session until we get to the solution. I don't know if you all agree with me. Everyone hearing now, if you agree with me, that we need to go to the next edition, the next episode of this. We can agree. We are going to find a way to pursue our barrister. Yeah, Kingsley has lifted up his hand. So many of us I see hands being lifted. To take this conversation further. Yes, and no, I supported. If you can just lift up your hand using the reaction button. Let's see our next intervention. Okay, I see Rome say, yeah, thank you. So let's take this conversation further. Barrister Awa, we will like to see if we can pursue the gazetted copy, even though Ijoma said we won't get that a gazetted copy. Festus, I see your hand. Yes, thank you. Even though we're not going to get a gazetted copy between now and the end of the month, but what can we do by next week? Because someone said, you keep saying it, you don't stop saying it. We need to engage. If we are going to have a conversation living from here to then engage, can we not tinker with that session that is problematic, that is an issue? Nobody's talking about the subsection 2. Nobody's talking about the subsection 3. Nobody's talking about section 2. Everyone's accusation is on that 8391. Why is it a challenge? I'll give my Kingsley, you want to say final word? Please permit me, we're already 11 minutes behind schedule. I will take 1 minute from Kingsley and 1 minute from any other person that wants to intervene. Then we give the last comment to Barrister Tete, our host today, our guest today, the very distinguished guest. So, Kingsley, I'm going to give you 1 minute. Please, 1 minute. Thank you very much. Go ahead. You can on mic, please. Yes, Kingsley.
Yes, thank you very much for all the participants. It's not. I don't think the problem many of us have has to do with regulation or accountability. It's about control. It's about the kind of control without limit. That is just it. So there should be some amendment, especially with that section 839, so that the courts will be more involved, so that also wherever there is discontent with the process, there could be appeal for that review. And again, there is just no reason why the smooth running of an organization should be interrupted for 12 months. This is Nigeria. So there must be some reworking of that section so that these fears will be allayed. Thank you.
Okay, thank you very much. Any other person that want to speak? Any other person? I still see people coming in where we are closing. Yes, there is nobody. Wow, I see a senior advocate of Nigeria coming in. When a senior advocate of Nigeria comes into where the small lawyers like us, who are public lawyers, even though I didn't read law, I know the power of the senior advocate of Nigeria. I'm sure he's already on board. I see, yes. Awomolo SAN. Sir, if you are in, the conversation is ending. I don't know if you are in, if you can just on mic, if you can speak to us. Yes. I'm trying to. If you can go ahead, sir. SAN, please. SAN, sir, please go ahead. Okay, all right. Let me believe that is because the microphone is already lifted. Okay, so we go we are having a final agreement now. By next week, Tuesday, same time at 2 p.m., we'll get another side of this conversation. But we must interrogate that session because Pastor Festus and everyone, you will agree that nobody tends to be talking about regulation. Everyone agrees with the fundamental principles in subsection 2, in the section 2, the court, even where they feel there's misconduct, there's financial misappropriation, and all of that. That is not an issue. But the issue is where there's a certain power. Where is the section 1, subsection 1 of the section 839. I mean, that section should be a Bible for all of us who go to church and should be a Quran for those of us who believe in this same analysis. Section 839, subsection 1 must be interrogated to the extent that we must have an agreement, because everyone that is against the new act is talking about that same subsection. Why is that an issue? We need to interrogate further. Frank Tete, you have the floor. So we conclude, and we'd like to say thank you immediately after. Frank Tete, you have the floor now.
All right, thank you very much. There are principles of interpretation. For every law that is made in Nigeria, there is an interpretation section. Then there is another law called Interpretation Act, which establishes the principle for interpreting all other laws. Now, the word order is defined by the Interpretation Act as an order proceeding from a court of law. A minister gives directives, except where the law grants the minister the power to make an order. In this case, my submission is that we must come to the conclusion that an administrative body cannot make an order that supersedes that of a court, where in a same section, the section refers to a court order. You don't need to be a rocket scientist or even a lawyer to know that it is a court order that is being referred to. Now, an order proceeds from court. Now, section 839 is not a problem at all. And if we have a problem, it is about the people who operate CAC or who operate CAMA. It is the same kind of problem we have at every level of governance in Nigeria. people who operate with a mentality of not of looking for shortcuts and then abusing power. We are not afraid of the section that I speak for. We're not afraid of section 839. It hasn't even been tested. And it is my prediction that CAC, those who run CAC on their own, cannot decide to say they are suspending any trustee. They don't have the power. The law doesn't give them that power. The power that is given is that they can make a petition to the court for the suspension of a trustee, just as 1/5 of the members of a church can make an application to the court that the pastor or the president or founder should be suspended. I'd like to end by saying that it is therefore important to determine who are members of an NGO, who are members of a mosque or members of a church. Those are the persons who have the real power. Those are the persons who have the ability to make the complaints to CAC. I have said it as a matter of practical knowledge that CAC doesn't know what's happening in many of the churches around the country. It is the members of those churches that will make complaint one way or the other. As for NGOs, and I appreciate the fears of my friend Olumesi, for example, that when an NGO becomes too critical, people like us and the showers of Nigeria and the Deji Jews, they don't require an NGO to criticize government in an impactful way. Government isn't afraid of all these NGOs. Now, if we are a country, and our aspirations as individuals is that we should improve in our operations, why should it be in Nigeria that NGOs will operate freely, churches and mosques will operate freely, collect money and expend money without knowledge of the members, without knowledge of government? That is the reason why the Muslim Rights Concern was accused of collecting $250,000 for the funding from a terrorist organization for expanding terrorism in southern Nigeria. That could not happen in a transparent environment. That is the same reason Mr. Magu, the past acting chairman of the EFCC, was accused of laundering money using a church. What kind of thing is that? Why should it be my country? I have operated in this sector to the point where I sat with counterparts from other countries, and I don't see anything fantastic about them. But they look down on us because we keep holding on to archaic laws, standards that portray us as corrupt people who don't want to be developed. This law shows that we don't have anything to hide. And those of you out there who want to donate monies to NGOs, to churches, you now have the opportunity to monitor how those monies are being used, because by simply applying to CAC for a copy of the annual returns that was filed by the NGO last year, you no longer need to send spies or hire private investigators. For goodness sake, we have just made some more progress with this new CAMA as it relates to the not-for-profit sector. I want to thank Igbe for this opportunity, and the director of Center for Democracy and Development, Ida Hassan, for giving me this opportunity to express this. I want to allay our fears. We have more important things to deal with as problems in this country, but if it is about this CAC Act, and particularly with Section 839, then that's not a problem at all. We have bigger problems to deal with. I want to thank you all, the criticisms, the education that I've received, the alternative views that I've also got, and particularly to the Honorable Chairman of the Abuja branch of the Nigerian Bar Association, Dr. Shekau. I want to thank you for that contribution. I thank you all. God bless you.
Thank you so much. In fact, this is a special edition of a series of engagement that the Center for Democracy and Development has been engaging with. Like you know, the Center for Democracy and Development is a non-profit organization charged with the mandate of facilitating conversations like this at the regional and international level. What part of our holding government accountable is what people, what we call Buhari meter. So anyway you hear Buhari meter, that is our kind of signature project. So we hold government accountable. Whether it's CAMA or no CAMA, we continue to hold government accountable. Let me thank Frank Tete, thank everyone. I say Farouk Danjuma, I say Babatunde, Adanu Moses, Kingsley, Biodun, Barisability, Boko, Professor Somarige, Pastor Professor Somarige, thank you. James, I see you. Austin, we respect you. Appan, we respect you. In fact, Kingsley, you jumped from, okay. Oh, sorry, sir. I think I need to give, before we close, we cannot close without giving the due respect to the senior advocate of Nigeria who is here with us. Sir, I won't proceed. We'd like to hear your voice. SAN, sir. Can you hear me? If you can on mic. Adegbo Yoga, please, sir. Left. Okay, it's back again. Yeah, microphone. Yes, if you could. All right. I mean, next time we can have a way of engaging. I would like to engage. We say you, Jerry. We respect you, Joseph.
I can hear you.
Okay, sir. We'd like to just hear your voice on, maybe for a minute or two, your thought about the new CAMA, especially with the religious and NGO freedom. What's your summary statement? We'll be happy to have you as a guest for next Tuesday. Sir, you have the floor.
Thank you very much, the moderator. Let me commend the organizers of this webinar. I have listened very carefully to almost all the contributions. I came in a little late, but yet I have grasped the totality of what they were saying. The last summary given by the gentleman who summarized captured my thoughts. You see, a lot of people have commented about section 8391 without reading the totality of the section. A law is not interpreted by one subsection, but reading the whole section together. I believe we have no reason to fear that the section may be abused. We are clamoring every day for accountability, transparency in public affairs, particularly in wherever money is involved. We must applaud the section. The only problem I have is that we must be conscious of the fact that the CAC Director General cannot act judicially. If there is any violation of the act, it is only a court of law that can impose sanction, not the DG himself. So we need to understand the role of the judiciary having regard to Section 6 of the Constitution of the Federal Republic of Nigeria, 1999. But for me, I would not waste much time until there is a disputation. And people who are not satisfied or who are afraid for whatever reason can go to court and ask the court to interpret the provision of Section 8391 or the totality of 839 with respect to religious organization. But for me, until there is a course of action, it is better to follow the rules, be accountable, be transparent in the management of the affairs of the churches or NGOs organizations. I am aware that in Europe, America, NGOs enjoy funding, and all these funding organizations insist on transparency and accountability.
Yeah.
So don't let us worry ourselves too much. It is a way to go. It is the new norm. Transparency, accountability in public finances. Thank you very much. I'm grateful for the opportunity.
Oh, thank you, Senior Advocate of Nigeria. Because of the time we've spent like 2 hours engaging. I wouldn't want us to drag more. I would like to have you, if your time permits, next week, Tuesday, if you could be one of our guests, we'd like to bring someone in on the other side. We need to have a clear debate, because some of us still believe that that subsection 1 of the 839 has to be tinkered with. And we need, you have already provided some leadway, which Frank Tete agreed, and so many people also agree with us on this other side. So to have a balance of engagement, if your time permits, next week Tuesday at 2 p.m., if you could oblige us your time to be our guest one of our guests next Tuesday.
Give me a call before then, please.
Okay, sir. Okay. If you could type your phone number somewhere or through the email you used to register, we'll follow you up on a phone call.
That'd be nice. Thank you very much. Well done.
All right. Thank you so much, Senior Director of Nigeria. Thank you, Blessing. Nena, I see you. Ichaka, thank you. Stella Okafor, you are well appreciated. We thank you. Henry, due respect. Israel Day, God bless you. Thank you. Jerry, I see you again. Well, there's Joshua, Austin Abu, thank you. Edmion Duke, Enon, thank you. Michael, thank you very much, Michael. Joseph, Fidelis, thank you. So many people, okay, Florence, Marcos, thank you. Everyone, Edikan, I'm very not careful so that people don't get angry when I don't mention their name. Beatrice, we also thank you. People are leaving, so the thing is going up and down. Thank you, everyone. Tolu, thank you. Florence again. Demilola Abudu, thank you. Oluwatoyin, thank you. Johnson Benson, Fidelis, Michael. So thank you. So next week, Tuesday, 2 p.m. again, we are trying to get on this conversation where we engage. We're going to have Frank Tete now sitting to now interrogate from the other side. We'll try to get in Barrister Awa Shekaro, Senior Advocate of Nigeria, just confirm. We are going to see if we can get Senior Advocate of Nigeria, Femi Falana, to come and engage to see where the dynamics are. Can we look at that law and again interrogate? Senior Advocate has told us there is no cause for alarm. See you next Tuesday. And thank you, everyone. So see you on Tuesday. Bye-bye.